Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question from one of our subscribers on our YouTube channel. Hey Patrick, what are some risks of not having an estate plan? Oh my. Folks, I talk about that in my book. Pull up your chair, get your pen out and your notebook because I'm going to teach you today, folks, about the 4 major risks of not having an estate plan. Folks, elder law care attorney Patrick Kelleher, our subscribers say, hey Patrick, what are the risks of not having an estate plan? Do I truly need an estate plan? Well, folks, would you go down a river without a paddle? Would you go out to sea on a boat maybe without a life vest, without some communication device? Probably not, right? Probably not a prudent, wise, safe thing to do for your loved ones. And folks, I'm a big firm believer that it is our personal responsibility to make good decisions, to take action, to take care of ourselves first and foremost. But when we take care of ourselves, we're taking care of whom else? Our loved ones, our spouse, our children, our grandchildren, whoever that may be in your life, that is your why. So folks, not having an estate plan, you're putting your family at risk. You're putting your family in peril of getting struck and bit by what I call the metaphorical four-headed monster. And that's the title of my book, How to Avoid the Four-Headed Monster of Estate Plan in Elder Law. Number one, probate court, because without an estate plan, and if you don't have your assets structured properly, typically assets are going to end up in probate court. That's the treasure chest right there, is what you want, but you don't want this dreaded ugly milk crate. And if you have a will is still your admission ticket to probate court. And if you don't have a will, and your assets are not held properly, and if they're in your name individually, they're still going to end up in probate court. Without even having a will, that is called the government plan, folks. You have the government plan. I talk about this in some of my other educational videos and programs. The government plan will dictate under the laws of intestacy, or the laws of intestate is what they refer to it here in the Commonwealth, who's going to get your stuff and how they're going to get it. It's typically your heirs at law. And your heirs at law will have to petition the probate court, the dreaded ugly milk crate, and not have the structured, organized treasure chest process. They're going to have the milk crate process. And that is probate court. And if you have a taxable estate in your state, like Massachusetts, we have a death tax. If you're over that and you do not have an estate plan, you're likely going to end up paying estate tax if you do not have proper tax planning in your plan. Of course, even with the government plan, your loved ones will get your stuff eventually through the arduous, expensive probate court process, but they're not going to have any bloodline asset protection that you could create in a trust. And of course, the fourth-headed monster, if you become incapacitated in a nursing home before you pass away and you receive Medicaid benefits, if you do not properly protect your assets like your home in your irrevocable Medicaid trust and beat that 5-year look-back period, there likely could be a big lien on your estate. And then the nursing home's getting reimbursed. Medicaid is getting reimbursed for the Medicaid benefits they paid. So that's the risk right there, folks, the metaphorical four-headed monster. You risk not having an estate plan. You risk getting bit by probate court. Why do folks want to avoid probate? Costs too much, takes too long. Here's the tax man right here. The tax man can represent estate death tax as well as capital gains tax as well. Here is bloodline asset protection for your children and your grandchildren. You won't have any of that with the government plan, and you certainly won't have any protection from a nursing home if you end up on Medicaid benefits in a long-term care facility later in life. So there you have it right there, folks. You also will not have the Big 6 disability planning that we talk about in our other educational videos, like power of attorney, healthcare proxy. The Big 6 I refer to as power tools to also keep your affairs out of disability probate. We've seen cases where it's costing families $50,000 when the probate court gets involved, appointing a legal conservator, which is a court-appointed attorney to legally step into your shoes and manage your financial affairs for you. That typically happens when someone does not have an estate plan. Easy breezy, lemon squeezy. Create a durable power of attorney in advance when you're alive and well with enhanced elder law powers, and that will slay the conservatorship beast at the probate court typically, so long as it's done properly. And what I mean by that, if it's drafted and prepared by an experienced elder law attorney, that should be sufficient to avoid conservatorships and guardianships at the probate court process that I refer to as the messes and stresses of probate court, as well as the economic and emotional headaches of probate court. Folks, there you have it right there. You can replay this video, take notes as needed. If you'd like to learn more, pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, because you will learn a lot. Also, click the subscribe button to stay informed, and the notification bell, because we'll update you. We'll give you a notification every time we release a new educational elder law video. Follow us also on our other platforms such as Facebook, Instagram, and also now TikTok, and of course YouTube as well, and on our website elderlawcare.com. Folks, thanks for joining us here today at Elder Law Care.